lawyers.
You and I can't be dragged there.
Exactly. So they are going there as lawyers. And they've been going there. Brandy. Second point. Yaopon, Marita, Burapia, and Frank Davis were cautioned in the course of the proceedings of the election petition. That was the first signal. We are talking of sequence. Why, when they were cautioned, the best thing that the court will take serious view of that thing they had been doing to the extent that they were cautioned. That's what it was. So I'm not able to concede that that caution compared to the subsequent actions was discriminatory or selective. It wasn't. It was a preliminary alert given to everybody. All lawyers have been connected or unconnected to the issue.
Like a warning.
Yes, and you actually indicated that earlier. So we cannot mix the two. It is subsequent to the caution that was issued to the three, I think there were three or so, that Dr. Yimi's contempt matter came on board. And he was dragged before the court. He purged himself of whatever contempt they alleged he had committed. He even got a former bar president of repute to come and support his case in court live. Is it Bicham?
Okay. Yeah.
Am I right?
Yeah. Frank Bicham.
Yeah, Frank.
Very senior.
We all saw it. Yeah, very senior. And very respected.
Yes, former GB.
And indeed his presence alone. It's like the Sir John Ayikui thing. It helps. Everybody there, they are all human beings. And that's when I finish, you see the angle about the key question you asked. So let's please draw the lines of distinctions carefully and critically. Dr. Ayini, when he appeared, in a way, clear to everybody, considered he was wrong. And so asked for forgiveness, quote unquote. He was paid. I'm even told that it's been expunged from the record, so there's no record. Then don't forget who he is, the former Deputy Attorney General, a top good lawyer. So for that to be erased, it's in his own interest. Subsequent to that, he appears for a food, very important food that I support in principle, in terms of judicial review dialogue series. That's the title. He makes comments similar or same what he had made earlier that sent him.
And that kind of dialogue is a dialogue with the intent of critiquing judicial decisions.
Exactly.
Right? Okay.
And to help.
So just like the Riakoto,
I have no problems with that. The principle is good. I support it, and it's not new.
Yes.
It helps our jurisprudence, improves subordinate and everything. No doubt about
In fact, it's something that is done at the law school every day.
Yes. And there are journals publish those things.
Peer reviews.
Yes.
So
again, the context is not the same as the Supreme Court's proceedings on the election proceeding was. So it's not the same.
Yes.
But you see, and I have no difficulty personally with what he said at that forum, personally. And that's why I even made a case, and that's perhaps where your answer lies, that perhaps the CJ's reaction was an overkill. And that if I were in his shoes, or if I were to have the opportunity to advise, which I know I would never have, is to say that ignore and let's move on. But there are other schools of thought, legal and judicial, who say that if you make the statement he made and link it to the lack of independence of the court relative to the decision they arrived at, you are actually questioning the integrity of those who sat on the thing.
Could the answer also not be linked to the question asked?
Yes, but you don't get my point.
Yes,
I'm telling you what a certain school of thought have advanced.
Okay, whether you agree with that or not is another matter. Okay, all right.
Okay, but they're making that case that if you, the substantive point is that you are more or less suggesting that the panel, at least that sat, lacked some independence, which is why they arrived at the decision they arrived at. That's the point some people are making, a logical deduction or an inference and all the rest. I still stood by the point that, look, allow it to flow and let's move on. But Randy, there's something that is worrying, and I've seen his latest response
To the GOC.
The Administrative Secretary of the General Legal Council.
Yes.
Very powerful, well written, articulate. This is what I thought he could stand by all the time, even at the Supreme Court.
Sometimes situations demand.
So was it fear?
Maybe it was strategic.
Driven by lack of courage of conviction?
Oh.
Well, so, you see, but that's the point.
Maybe at the time he thought that.
Let me tell you, that is the point I'm making. What are we doing? Here we are, Sammy even made some allusions to the fact that some of the rules and things, maybe a bit, I don't know what word to use so that I don't put words in his mouth, but it's like you must review, you need to look at it again. Even the composition of the General Legal Council is different. He was going in that drift, and there may be some merit to that. But you see, the point I'm making is this. We're talking about lawyers.
Right.
Learned minds. That's who they are. Trained.
That's what they call themselves.
They are. The study law is not a joke.
No, but that's what they call themselves. It doesn't mean that they are more learned than other professionals.
Okay, I see your point.
So that's how they refer to themselves, and we are fine with it.
Learned profession.
That's how they call their profession.
It takes a lot of thinking.
It takes a lot of thinking in journalism as well. It takes a lot of thinking in engineering. It takes a lot of thinking in medicine.
I need to give up. I hear you. You see, my worry is this.
Right.
The NDC statement. And it's the NDC intrusion that has